and share my screen. Okay, thumbs up there if you can see the screen quickly. Just confirm to me. Somebody just give me a thumbs up if you can see the screen. Thank you. How do you pronounce your surname? Sharuma. Are you from Zimbabwe?
Yes, I am.
Okay, well, welcome to Namibia.
Thank you.
Right, we're busy looking at the requirements for a valid contract. What we've seen so far is that a contract is an agreement between two or more parties with a serious intention of bringing about an obligation, with a serious intention to be legally bound. But these obligations can only come into existence if the contract is valid. If the contract is not valid, it is in fact not a contract, it is nothing. There are no rights and duties, no obligations that arise from a contract that is not valid. Now, for a contract to be valid, there are 5 requirements that this contract has to meet. Namely, there must be consensus, there must be contractual capacity, performance must be possible, performance must be legal, and if there are any formalities, these must have been complied with. Remember, however, that in general, contracts do not need formalities. Um, if you're getting into a taxi and asking the taxi to bring you to the NUST campus, that is a contract, but you haven't signed papers in duplicate. So then we stopped and we looked at consensus, the requirement of consensus. Now, consensus, complete agreement, is integral to contracts. Without consensus, there will not be a contract. But consensus is not the only requirement. There can be as much consensus as you like. Parties can be agreeing until they're blue in the face. If they do not have contractual capacity, if performance is not possible, if performance is not legal, it will not be a valid contract. So moving on then to look at the other requirements. We've looked at consensus. We've seen that in some instances there is consensus, but consensus was obtained in the wrong manner or for the wrong reason. The contract is valid, but it can be set aside. So we refer to that as a voidable contract. But until it is set aside, it remains valid and binding. Remember that. A voidable contract is not a special separate category of contract. It's not somewhere in between valid and void. It is a valid contract that can be set aside. So the further requirements there for a valid contract. Firstly, the parties must have contractual capacity. Contractual capacity is closely linked to consensus in the sense that consensus is a complete agreement to bring about obligations, complete agreement about the consequences, about the obligations. And of course, you can only truly agree if you understand the significance of your actions. if you truly understand what the consequences can be or are going to be. So contractual capacity, then, the ability to understand the consequences of your actions, the consequences of this contract. Contractual capacity affected by age as well as by your state of mind, your mental capacity. Simple rules with regard to age. Under the age of 7, there is no contractual capacity. Law deems you, if you're under the age of 7, that you are not capable of understanding these consequences. Between the ages of 7 and 18, you are said to have limited contractual capacity. You can enter into contracts, but you need the assistance of your legal guardian to make this contract valid and binding. There are some exceptions to this. There are certain types of contracts that somebody under the age of 18 can enter into without the assistance of a legal guardian. What exactly these contracts are do fall outside the scope of our studies. So under 7, no contractual capacity. Between 7 and 18, limited contractual capacity. And then over the age of 18, you are deemed to have full contractual capacity. Not everybody, however, that is over the age of 18 has full contractual capacity, because regardless of being over the age of 18, the law also takes your mental capacity into consideration. You must be able to understand several things that can cause mental incapacity. Mental incapacity can be either permanent or temporary. Not that many people in class, unfortunately, only 5 people in class. That's very disappointing. Anybody in class currently that plays rugby?
Yes, ma'am.
Mr. Sharuma, do you play rugby?
Yes, I do. Oh, did. I still
Okay.
do.
Okay. In what position did you play?
I've played from number 9 to number 15. So anyway, in the back line.
Okay. Now you should know, as a rugby player, whether you're playing as a forward or in the back line, there is always a real risk of being tackled and sustaining a concussion. Have you ever sustained a concussion?
Yes, I did.
I'm sure you did. It's a pretty regular thing, and the rules of rugby are also very, very strict to protect players against the consequences of concussion. If you're tackled and you deemed to, look, I'm not an expert on the rules of rugby, but as far as I know, even while the game is ongoing, if the medics along the field look into your eyes or something and feel, no, you've got a concussion, you have to leave the field. You're not permitted to continue playing. Am I correct there?
Yes.
Yeah. Now, why are you? Because of the effect that a concussion, a hard hit, has on a person's brain. Now, even a serious concussion can temporarily diminish your ability to fully comprehend um, the consequences of your decision to. So, if you've just played a rugby match and you sustained a serious concussion, and the next day or that evening after while still suffering from the effects of the concussion, you sell your car to some random stranger you've just met in the pub for $20 because no permanent effect on your brain, but at that stage, you cannot necessarily understand exactly what you are doing. So these are factors that can affect your ability to understand and hence affect your um, contractual capacity. I normally in class, but I think I need to stop doing this. I refer the piece in the study guide refers to intoxicated persons, people that are drunk or have used drugs. But it's not just intoxication that can cause this. So I'm just going to put in here. Seeing that you are literally studying sports management, you all come from a sporting background. So if there are factors that affect your contractual capacity, affect your ability to understand the consequences, it could be that the contract is void. If, however, you have now sold your car and the next day you realize, well, actually, you didn't realize what you were doing, either because you'd been drinking, which we trust would not be the case, or because you're suffering the consequences of a serious concussion. The person who claims that they did not have contractual capacity must prove this. So it will be up to you to bring the necessary evidence that at the time of contracting, you did not have the capacity to understand. There are certain circumstances, however, where this mental incapacity is of such a permanent nature that you can be declared sorry, mentally incapacitated by the court. In the study guide, in the study guide, I do refer to mental incapacity. Some study guides will, textbooks use the terminology being declared insane. I don't actually like the terminology declared insane. It's a bit of an old-fashioned word. But anyway, so if there is a court order declaring you mentally incapacitated, even people who have been declared mentally incapacitated can have what we refer to as clear moments. Where they actually do understand what they are doing. But this differs, the way the courts approach this differs from temporary incapacity. So intoxication, concussion, etc. If it's a matter of temporary incapacity, the person who claims they did not have contractual capacity will have to prove this. If there is a court order, so if it is a permanent incapacity, if there is a court order, the person wishing to hold this person to the contract will have to prove that they had a clear moment. So to summarize, Above the age of 18, people are deemed to have contractual capacity, and they will have to prove that they were incapacitated if they want to escape a contract. Unless there is a court order declaring them permanently incapacitated, then the person who wishes to hold them to the contract has the burden of proof. So the next requirement, performance must be possible. There are two aspects to the fact that performance must be possible. In the first instance, we need to know what must be done. What is the performance? So the performance has to be determined or ascertainable. In order for performance to be possible, we need to know what actually needs to be done. In addition to knowing what needs to be done, it must also actually physically be possible. With regard to the physical possibility of performance, can this be done? The law distinguishes between objective impossibility of performance and subjective impossibility of performance. Objective impossibility, nobody in the world can do this. Subjective impossibility, one of the parties to the contract cannot do this, but it would be possible for anybody or for somebody else. Let's say with Mr. Sharuma as an example, you're my lucky winner today. He is a rugby player, ex-rugby, still a rugby player. So let's stick with rugby. So let's say a sportswear manufacturer enters into a contract with a top rugby player that they will sponsor him, pay for his X amount of money, sportswear, blah, 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 blah. If he scores 5 tries during the course of a season. Mr. Sharuma, do you think it's possible for your standard to good rugby player playing in the back row to score five tries during the course of the season?
Depending on how long the season is, that is viewed as low performance. It has to be above 5.
Okay, yeah. So my answer
So
that I wanted from you, this is standard. This can be done.
yeah, it can be done.
It can be done. A contract asking them to score 500 tries in the course of a standard season.
It is not as attainable.
It is not attainable. That's the point that I'm trying to make. The difference between objective impossibility of performance and subjective impossibility of performance. Objective impossibility of performance, 500 tries in the course of a standard season. It's not going to happen. Even if you are the best rugby player in the world, it's not going to happen. It is objectively impossible. 5 tries can be done. If, however, they enter into a contract with me and expect of me to score 5 tries in the course of a season, I've never held a rugby ball in my hand. Obviously, the performance is going to be impossible, but it's impossible for me. It's not impossible for everybody. You see what I'm getting at? I'm trying to illustrate the difference between objective impossibility of performance and subjective impossibility of performance. Objective impossibility of performance, 500 tries in a season, not possible, not going to happen. Your contract is void because the requirement for possibility that performance must actually be possible is not met. Subjective impossibility of performance, the particular contracting party cannot perform. The contract will be valid. And if it's a particularly good rugby player and the minimum was 5 tries in a season and he didn't have a good season, he only scored 3 tries, it could be that he can be in breach of contract and there can be consequences. We look at that in a further unit. But objective impossibility of performance. So you remember to distinguish between objective impossibility of performance and subjective impossibility of performance. Just give me a second. Okay, my apologies there for the interruption. So that is possibility of performance. Moving on then to performance must be legal. If performance of the contract is against the law, so selling of drugs, etc., obviously the contract is going to be void. With performance must be legal, we're not only referring to the law as such, but also contracts that are deemed to be against our good morals will also be void. So if I were to enter into a contract that let's continue referring to Mr. Sharuma, that I will pay him $1 million if he marries my daughter, that contract will actually be void. Because contracting with somebody to marry their daughter, literally buying a bridegroom, is considered against our good morals. Another aspect of the fact that the contract must be legal, which is interesting, and also make a note of this because I often, very often, do ask this in assessments. In fact, one of the questions in your assignment that I have already distributed to you is based on this, namely the contract of restraint of trade. Contract in restraint of trade is an agreement that restricts the liberty of one or both of the parties to engage in one or more specified commercial activities for a specified period or within a specified geographical area. The example that I used in the study guide, it is an actual example of an Australian cyclist, who in his contract with the Australian Cycling Federation's governing body, whatever they called, there was a provision that should he decide to leave or to no longer cycle for Australia, he has to sit out for a period of 2 years before he can then participate under the flag of another country. It is actually also in the sporting world a fairly normal, a fairly common type of agreement that is found. A club contracts you, and in your contract it is specified that should you leave that club, you are not allowed to play for another club for a specified period of time. Reason for restraints of trade: to protect trade secrets, goodwill, guard against competition, etc., etc. Now the question arises, this restraint of trade, is it actually legal and enforceable? Now, why do we ask this question? Because if we start looking at a restraint of trade, this agreement restraining somebody's right to do something, to participate in their trade of choice, actually brings in conflict two constitutional principles. Firstly, in terms of our Namibian constitution, all people, it is a guaranteed freedom in our constitution that all people have the right to freely participate in trade, in the trade of their choice. And this restraint of trade is literally preventing them from doing this. And of course, the Constitution is a law. If the Constitution says you're allowed to do this and you say, no, I'm not going to allow you to follow the Constitution, you're literally acting against the Constitution, you're breaking the law. So in terms of what I've just told you about contracts must be legal, it would follow that this contract of restraint of trade would be void. On the other hand, there is another principle which we follow, namely that it is in the public interest that contracts should be upheld. And this is a contract that you entered into freely. Accordingly, it is in the public interest that you must be held to the contract that you entered into. So we're sitting with a conflict here between two different principles: the right to freely participate in trade and that contracts must be upheld. The approach of our courts is generally that contractual commitment, contract should be upheld, is the stronger of the two principles. So that give more weight to the fact that contracts must be upheld. And accordingly, generally, the courts will hold that a restraint of trade is enforceable. If you are party to a restraint of trade and you don't want it to be enforced, you want to escape from it, the person who does not want to be bound will have to prove that it is unreasonable. So a contract restraint of trade that you may not play for a competition club for 1 year might be considered as reasonable. Contract that you may not play for a competition club in the whole of Southern Africa for a period of 10 years, obviously unreasonable. Okay, everybody with me, any questions about that?
Not a question, but more of like a comment. Um, I understand the contract of restraint of trade, but to counteract this conflict, is there a possible way where they can introduce? Well, I mean, it's already there to sort of do an NDA instead of restricting someone from pursuing what they want to do, since it's
Yes,
about
yes, NDA, of course, we're talking about contractual freedom.
if
And we're talking about,
sorry.
yeah, we're talking about people that are contracting on an equal footing. So we're not talking about an employer-employee relationship where the employee is basically sort of almost bullied into signing whatever because they're desperate for a job. Talking about people with contractual capacity contracting on on equal footing. And of course, they can then, when they enter into the contract, decide what do they want in this contract. And yes, you are 100% correct. An NDA, a non-disclosure agreement, is probably a more reasonable way of protecting trade secrets rather than a restraint of trade. Because a restraint of trade denies you the right to be actually do your employment of choice, whereas an NDA, you can still do your job of choice. You must just keep your mouth shut. Um, so yes, that is something that people can negotiate when they enter into this contract. But if there is a restraint of trade in a contract, the, a court of law will never change somebody's contract. A court of law will say the restraint is enforceable or it's not enforceable. A court of law will not say, okay, there's a restraint of trade, but we're going to change it into an NDA. The court won't do that. The court adheres to the original contract or says original contract not enforced. Okay, but good question there. Thank you for asking that. It's nice to see that you understand and you're thinking a little bit wider, sort of applying in context. Okay, and then the last requirement is formalities, whether or not the contract must be in writing. If there are prescribed formalities, for example, sale of buildings, immovable property has to be in writing. So if those formalities are not complied with, contract will be void. But in general, formalities are not required. Okay, so now we've looked at the requirements for a valid contract. So now we have anything we learn subsequent to this with regard to the law of contracts. Remember that the contract is now valid. Once a contract is valid, it doesn't suddenly, randomly, abracadabra, become void. So Unit 5, that's also required for us to do today, is about the parties to the contract. Just very briefly, an agreement between two or more people with a fixed intention to create obligations. For these obligations, we will always have a debtor and a creditor. Those are your parties to a contract, the debtor and the creditor. But be careful here. Because I think you do in your first year, do you do business accounting or something like that? If you've studied accounting, you would have come across the terminology debtor and creditor. In law, in the law of contract, when we're referring to debtor and creditor, the meaning is similar but not exactly the same as in accounting. Because contracts aren't always only about money. So the debtor is the person who has the duty to do. Put this in capital letters, in capitals here. You must always, while you're studying, I've been doing this for years, and I'm an old lady by now. It's very useful to have, we used to call them donkey bridges, a little way of remembering something. A creditor has the right to receive. So if I've sold my car, let's give Mr. Sharuma a break for a change. Let's move on to Mr. Hayala. I've sold my car to Mr. Hayala for $200,000. In this contract, there are various obligations. There is the obligation to deliver the car. With regard to that obligation, it is my duty to deliver the car. And Mr. Hayala has the right to receive the car. So I'm the debtor, he is the creditor. But there's also the obligation that he must pay me. He has the duty to pay me, the duty to do. He is the debtor. I have the right to receive. I am the creditor. So in the same contract, the same people are both debtors and creditors, depending on the nature of the obligation that you are referring to. With regard to the obligation to pay, he is the debtor. But with regard to the obligation to deliver the car, I am the debtor. Debtor, duty to do. Creditor, right to receive. Not complicated. Just remember that. Okay, and then paragraph 2 of Unit 5 is about agency or representation. There's a whole separate unit on agency that I do that in detail. Paragraph 3, contracts on behalf of, for the benefit of third parties. You can omit that, you can leave that out. I will not assess you on that. Then let's just quickly look at transfer of contractual rights and obligations. So if you want to change the parties to a particular contract, our law allows for that. Transfer of a right is known as cession. You need to know this terminology. So I have sold my car to Mr. Ayala. He needs to pay me. But in the meantime, for what reasons, whatever, I would like that money to go to Ms. Kantewa. I can cede my right to receive this money to Ms. Kantewa. Transfer of right, cession. This has got nothing to do with Mr. Hayala. He cannot refuse. He has to pay the money. It doesn't matter who he pays the money to, whether it's paying it to me or whether it's paying to Ms. Kantewa. It doesn't affect him. As long as it doesn't burden him, he does not have to give permission. So if there's a cession agreement, the debtor who has to pay the debtor does not have to consent, but obviously I need to inform him. I do need to tell him, listen, you no longer have to pay me, you have to pay Ms. Kantewa. But is there a question? Sorry, I thought there was a microphone on in the background. So transfer of rights is known as cession. The debtor needs to be informed, but they don't have to give permission, as long as it doesn't make things more difficult for them. Transfer of a duty, however, is known as delegation. So instead of Mr. Ayala paying me, he delegates his duty to pay to Mr. Links. If it is a delegation of duty, the creditor has to give consent. So if I sold my car to Mr. Ayala and he has the duty to pay me, and now he informs me that he would like to transfer this duty to pay me to some random person that I don't know. I need to agree that I will accept payment from this person or not. If maybe I'm not sure that this person is actually going to pay me. Because remember, the moment the delegation has been completed, Mr. Ayala no longer has the duty. He's passed his duty on to somebody else. It doesn't fall back on him. So delegation can only take place if the creditor has consented thereto. Okay, any questions about that? That's really all you need to know of Unit 5. It's very short and sweet. It becomes relevant again in other units, which is why I need to these are basically just legal terminology that I had to do with you quickly. Any further questions? If there are no further questions, I thank you for attending. I am slightly behind with uploading the lectures on YouTube, but I will sort all of that out in the course of the weekend. It just actually uploading them onto YouTube, depending on your connectivity, sometimes takes quite a long time. So yes, but I will attend to that shortly. So thank you so much. And I will then see you next week, same place, same time. Bye.
Bye.